Thanks to all of you for joining us today. I'm Trevor Morrison. I'm the Dean of the Law School here. This promises to be a really terrific conference, and for maybe the first time in my time as Dean, I think I'm able to attend some of a conference as opposed just to introduce it. So I'm looking forward to that. So this is the NYU Law Alumni Association Fall Conference, Democratic Distortions, a postmortem on the midterm elections. You all, I hope, have the program and can see the layout for the day. I want to just say a couple of words of thanks before turning things over to the first panel. First, to my colleagues Rick Pildes and Sam Issacharoff, who are the convening and organizing brains behind the day, and that's been no small amount of work. And so thanks to both Rick and to Sam for not only being key parts of these panels, but for putting so much time and thought into the overall organization of the day. I want also, of course, to thank the Law Alumni Association and staff here who have helped put things together. And then I want especially to thank Bill Berkley, the chair of the NYU Board of Trustees. Bill plans to be here for part of the day, starting late morning, but it's thanks to his very generous support that we've been able to put this conference on. And so great thanks to Bill. It's a sign of the support of the university, of the work we're doing here at the law school, and we're very grateful for it. So without further ado, I will turn things over to the first panel, which is on gerrymandering and political polarization. Thanks for being here.
Thank you, Trevor. I'm Sam Issacharoff. This is our first panel. I want to not take time with introductions. I just want to say that we have people who have been on the front lines of these cases. We have people who've been on the front lines of the empirics of these issues. From my left, all the way on the left, we have Patrick Egan, who's the perhaps most junior member of our panel, who's a political scientist here at NYU who specializes on issues of political organizations and political participation questions. And then to his right, we have Paul Smith and then Erin Murphy. And Paul and Erin squared off in the Supreme Court in the Wisconsin case. They argued the opposite sides of it, and they continue to be the central litigators in these questions coming from a number of different states. On the other side, we have Adam Cox, our colleague here, to Rick Pildes, and then Adam Cox, who's a colleague at NYU and has written extensively on the empirics of gerrymandering and how you conceptualize the question of representation across the polity and not just within a district. So he's a bit of an outlier in the direction in which the Supreme Court is going now. To his right is Steve Ansel-Behere, who is a political scientist at Harvard and is the most technically able person I know, period. And he has data on anything, and so we will ask him about that shortly. And to his right is Jamal Green, who's a law professor at Harvard, constitutional law.
At Columbia.
At Columbia.
You demoted me.
No. I don't know if promotion, demotion, but the Harvard was on my mind because he is the author of the about to appear? Has appeared Harvard Forward this year on questions of how we conceptualize constitutionalization of democracy, what are the ultimate aims, and ties in directly here. So to begin, we thought we'd read you something from an opinion in Maryland, a concurrence by Chief Judge Breeder of the District of Maryland last week, in which a court struck down perhaps one of the two really significant cases out there right now, the other one being North Carolina that my colleague Rick Pildes is involved in, that Erin Murphy's involved in. But in Maryland, you have a Democratic gerrymander of the state, and it was struck down as a violation of the associational rights of Republican voters in one part of the state. And Judge Breeder wrote as follows: "Partisan gerrymandering is noxious, a scourge on our democracy. Yet setting a standard by which to measure the lawfulness of particular partisan gerrymandering has to date proven impossible. Today, this court addresses that question. I'll excerpt a little bit. I wholeheartedly join the conclusion that current Maryland gerrymander infringes the plaintiff's valuable associational rights protected by the First Amendment. So this is a different conceptual breakthrough. It's not a discrimination case, not an equal protection case. It is that there is something fundamental in the gerrymandering question that distorts our democracy, which is the theme of this conference. And so let's begin with just an empirical assessment. Steve, you've been quite skeptical in your writing on how much of an impact the gerrymandering question has had over time. What's your assessment of the 2018 elections and how much can be attributed to line drawing, how much of an impact it had?
So one way to think about this is how many seats do we think that one party or the other would have won or lost as a result of the lines being drawn in a particular way?
Hold the mic up.
Another way to think about this is whether or not the line drawing is somehow creating political parties that don't function in a very good way. That's usually the polarization debate. So one is a question of bias. Are we getting skewed representation? And the other is a question of polarization. As an empirical matter in political science, these are both extensively debated questions. And the first place to turn in thinking about redistricting and gerrymandering is elections that are not districted, like senates, governors, and so forth. And those tend to be just as polarized as other kinds of elections. So as we start to make comparisons like that in the empirical literature, it's hard to find clear evidence that it's gerrymandering that's causing the polarization in the polity right now. It might be the other way around, which is the polarization of the polity is fueling the temptation and desire to gerrymander. And I think that's worth considering further. The question of representativeness is an old one and goes way back. If we went back to the decades before Baker v. Carr, the problems were far more severe. For example, much of the southern U.S. polity was a single-party system, and that was sustained in part by having unrepresentative legislative districts and congressional districts. Baker v. Carr helped take that apart, as well as kind of single-party states in the Northeast. And over time, what's happened is we've gotten much fairer political competition in the United States as a result of court intervention in the districting process at the level of something simple as one person, one vote, and forcing legislatures to make deals and negotiate over districting. What we do know is that when we get unrepresentative outcomes tends to be when one party controls the districting process entirely. So in states where the government is controlled by one party for both chambers of the legislature and the governorship, and where the legislature draws the map, which is not everywhere, then we tend to get pretty significant biases. But when there's divided government, something we tend to say we don't like, we actually get fairer, much fairer outcomes, or when courts intervene and draw maps, or when commissions draw maps, we get fairer outcomes.
So I'm in an awkward role of being both a moderator and questioner here, but also a participant in a lot of these issues, including the litigation going on right now, challenging the congressional districts in North Carolina, which is going to be the next big case the Supreme Court decides on partisan gerrymandering. I thought I'd actually just give a little bit of perspective because I have a slide that demonstrates the point Steve was just describing. I don't have too many slides, but I'll show you this one. So hopefully you can see this, and this is just to illustrate what Steve said, which is one way you can begin to think about partisan gerrymandering is by asking over time, how many states were under unified party control, and how many congressional districts did that give them the chance to gerrymander. And this chart on the top goes through the 5 decades of redistricting we've had. We've only really had the modern system of redistricting since the 1970s, after the Supreme Court required one vote, one person, which meant every decade after the census, districts had to be redrawn. So the blue line shows you out of 500, or 435, but congressional districts, how many could be drawn completely by the Democratic Party, how many could be drawn completely by the Republican Party, how did that change over time? And what you see here is in the 1970s, the Democrats had a slight advantage, and in the 80s and the 90s, the Democrats really were in the driver's seat in terms of the opportunity to gerrymander. And by the 2000s, kind of remarkably, the two parties have unified control of almost exactly the same number of seats in different states. And then one of the significant changes is that in this decade, for the first time in the 5 decades of redistricting, the Republican Party has the ability, at least, to gerrymander many more congressional districts. So this just nets that out and shows you that about 100 congressional districts in this round were under unified Republican control compared to these prior decades. Now that doesn't mean those districts were gerrymandered. That's just the initial opportunity to engage in gerrymandering. And that just illustrates, I think, concretely the point Steve was making.
So let's turn to the litigants to get response. So, Aaron, the Maryland record includes the governor saying, as the charge to the redistricting body, you are to draw as many Democratic districts as possible. The lines reflect the intervention of political authorities in the state, and the court strikes this down. In some ways, Maryland has been so under Democratic control in recent years that it just seemed that they didn't have to hide the motivation or anything. But when we probe in most states, we find kind of similar motivations. So is the First Amendment a fertile way to think about this? Is there an impact requirement, a threshold impact requirement under First Amendment law in your view?
Well, I think that there's both a reason that litigation has moved in that direction recently, and also a reason to question whether it will continue to do so. I mean, we have one justice who was very interested in exploring the idea that this is a First Amendment problem, and that was, really began with Justice Kennedy. When this issue goes to the court again this year, we will have a different set of justices on the court. And, the First Amendment theory was considered back in the Vieth case, and several of the justices there said something that I think will be, a big question as the courts are thinking about these issues right now, which is, if you think about this as, if you think about kind of intentional partisan gerrymandering as sort of discrimination in the First Amendment sense, then how do you have any real limit or stopping point on the theory? Because you're going to be able to essentially say that every time there's any districting that was intentionally for partisan advantage, you have a First Amendment problem. And I think that's precisely where the court got a little bit concerned with the idea last year when we saw this issue kind of being litigated in the Maryland case. You had several justices, even justices who were more kind of amenable to the idea that courts should be doing partisan gerrymandering claims, asking that question of, well, if we kind of go in that direction of thinking of the intent itself to district for partisan advantage as a kind of First Amendment violation, then doesn't that mean that pretty much every legislatively drawn map ever is going to be subject to heightened or even strict scrutiny and face judicial challenge, and all of this will be in the courts all the time? And I think that that's one of the difficulties that has persistently been there with the idea of, of once you drill down past thinking it sounds attractive in the first instance to how do you really would make a First Amendment theory work in this context.
Well, I find that a persistent problem. In my earliest writings in this area, I drew the conclusion from this kind of an approach, although it was more on the structural side, that there was no stopping point short of it has to be a commission, it has to be a nonpartisan body, because once you introduce the element of discrimination, it seems the reductio logic is going to take you to the point that any infection of the process is going to doom it. So, Paul, is there a stopping point in that you've been, not that you've been able to, but that one could envision the court's finding that would take you to the point of not striking down every partisan involvement?
Well, let me answer that, Sam, by sort of noting that we're in a really interesting situation now. In the wake of the Wisconsin case last June, where the court largely punted, except to say that you have to litigate these cases by having plaintiffs in each of the districts that you're challenging. You can't sort of go statewide in the way that we did and say that all Democrats are harmed by this gerrymander. As a matter of standing, we have now essentially three different approaches to try to litigate the merits of these claims, all of which to some extent, or to a lesser or greater extent, use the First Amendment. I don't think that and nobody has a sort of monopoly on that. In the Maryland case, the argument is really focused on the single district in the western end of Maryland, and the argument is the deliberate decision at the direction of Governor O'Malley to change the district in that general region from a red district to a blue district was itself a violation of the First Amendment rights of the Republicans who lived in that district, irrespective of whether the overall map is fair or unfair. They don't even make that argument. So they're not really talking about vote dilution of Republicans in general in the state of Maryland. They're simply saying it was a kind of retaliation against the people who lived in that part of the state, and that becomes a form of First Amendment violation. What that does, as Aaron was saying, and as some of the justices recognized last year, it does push you in the direction of saying every time you draw a new map, to the extent that you're deliberately creating a district that's either red or blue in a particular place, you're going to be subject to the argument that if you changed that region of the state from one to the other, you violated the constitutional rights of the people who are no longer happy with the complexion of the district they find themselves living in. In the North Carolina case, the congressional case that's going to be argued this year, there are two groups of plaintiffs, and we have somewhat different theories about how to prove this. We're all using individual plaintiffs at the district level, but the Common Cause group that Rick is working with is analogizing now partisan gerrymandering to the doctrine of racial gerrymandering. And racial gerrymandering is a doctrine that arose in the 90s and says you can't over-consider race in drawing a district. Remember all the really ugly districts in North Carolina that went down the highway, or the ink blot districts? That's where this doctrine arose. And they're saying essentially, we're going to look at it district by district and tell you that these particular congressional districts, they considered race, they considered politics excessively. And we're going to say that there's packing and cracking in this particular place, and it is excessive consideration of partisanship. And they too are reluctant, at least, and Rick can explain maybe whether I'm overstating this or not, reluctant to look at the statewide effects. They want to avoid the sort of overall comparison that says, like in Wisconsin, when I yelled at Aaron last year, you get 50% of the vote, you get 65% of the seats. That kind of thing that is what people instinctually think of when they think of gerrymandering. Now, the League of Women Voters plaintiffs in the North Carolina case that I represent are doing a somewhat different analogy. Essentially, we're analogizing to a litigation in the racial vote dilution context. Under Section 2 of the Voting Rights Act, if you can show you could create another minority district in one part of the state, and that there's there's polarization in voting, so that if you don't create a minority district, the minority won't have a chance to get representation, then under the Voting Rights Act, you have to create that new minority district. But there's a limit on it. You have to take a statewide focus and say, too many minority districts, you actually overrepresent the minority under a case called Johnson versus DeGrande. And so we're trying to combine a kind of district-by-district focus, but with, at the same time, saying you also have to look at it statewide and say, is this map overall fair or unfair, symmetrical or unsymmetrical? And that's what the North Carolina District Court did. It kind of did both at the same time. And it'll be very interesting. I'm happy if either one of these approaches works in North Carolina. The common cause approach, the one I was describing before, tends to push again in the direction of saying any amount of invidious partisan motivation is too much. Ours is a little less that way. It says too much bias in the overall map is too much, but of course that creates a line drawing issue for us, which the other team is trying to avoid. When is too much bias as opposed to just a little bias? And we have various measures we tried to use in the Wisconsin case last year to measure the degree of bias, but it is a bit of a problem. When you start looking at statewide, you have to draw a line.
Erin, I assume that you think Paul's theory fails.
She hates all these theories.
They're all wrong.
No, but I want to push a little more on a particular. I assume you think Paul's approach is forbidden by the Gill decision as raising issues that one does not have standing to pursue?
You know, I mean, I'm the first to say it's like a little hard to know exactly what to take from the Gill opinion.
You're not the first.
You
You're
know,
the
and as a practical matter, I mean, we'll see how much the court wants to take from the Gill opinion this year. I mean, there's so many caveats going on. It's an intentionally narrow opinion. It's sending it back down, but not even being clear about whether the court thinks there's anything to send back down. You know, so it really, I mean, it you know, it worked to get my clients a win, and you know that's always a good thing as far as you're concerned at the court. But in the broader scheme of things, it leaves, you know, I don't think it leaves a lot of things unanswered. And I think the thing that that is notable about it is, I mean, I certainly get the kind of the instinct that partisan gerrymandering feels more like if there's a concept of it, it's more of a statewide thing, yet that's precisely what makes it very difficult to come up with a theory that works for the courts. And I think it's right to be looking at Gill and saying the court seems to really not like that, but then it kind of leaves you with, well, are they saying they just don't really like all of this at all? Or are they saying, no, please go try and then do district specific? So, you know, I mean, I think that from our perspective, you know, I think the kind of theory that Paul is talking about doesn't solve the kind of basic problem that you've always had in this context, which is a little distinct. It's a sort of variation. I think the First Amendment problem in my mind is every single map is going to have this problem, whereas I think the kind of equal protection problem is more the problem of, okay, if you start from the premise, as the court traditionally has, of some degree of intentional districting for partisan advantage, some degree of intentional partisan gerrymandering is okay, then it's very, very difficult to say, how do you decide, you know, this one's okay and that one's not? And, you know, I've yet to see a test that I think kind of gives an objective way for courts to measure that in a way that at least this court is going to feel really comfortable that they will think that they can come to outcomes that won't themselves look political.
Erin, can you say a little bit more about why you think some amount of partisan gerrymandering is okay? I mean, the court did say that initially. No one's ever given an account. None of the justices have ever given an account. I've never seen, actually, in the academic literature, much of an account of why some amount of partisan gerrymandering is perfectly fine in the democratic system. There may be a sense it's going to happen, but, you know, even in the patronage context, where the Supreme Court said it's unconstitutional to hire or fire people, for government to hire or fire people based on their political viewpoints, there were arguments as to why there were some good things about patronage hiring. It integrated immigrant communities, for example, in cities. What is there that's good to be said on behalf of partisan gerrymandering?
So
even in modest amounts,
Yeah.
what public purposes does it serve?
I mean, I think one of the fascinating things is that there is a justice who wrote an opinion to defend what he saw as some of the benefits of partisan gerrymandering, and that's Justice Breyer in his opinion in the Vieth case, which begins with a discussion. I mean, it's you know, not who you would expect to be discussing what he sees as some of the kind of reasons that it's not, that there are some democratic goods in it, in the sense of what he talked about it in terms of is that, you know, that there's an accountability aspect to it, of knowing exactly who it is and what they're doing and what they're drawing, and that that there's, that it kind of has a representational benefit. But that said, frankly, I think the reason the court is consistently saying, and I don't think it's just some stray thing, I mean, I think in pretty much every decision you ever look at, going back, pretty much every justice, with maybe the exception of Justice Stevens, but I'm not even sure if he's in this camp, every justice has always said some degree of this is okay. And I think the reason they've actually said that is because the framers are, we're not fools. This isn't a new concept. The term gerrymandering dates back to almost the founding itself, and they intentionally gave districting to the legislature. They understood that they were having the politically elected and politically accountable individuals draw the districts in which they would be elected, and they made that choice. And so if you're thinking about this in terms of, is there some sort of constitutional problem? Is this constitutionally impermissible in the sense that, even doing it at all is unconstitutional? That's extremely difficult to reconcile with the notion that our Constitution intentionally and expressly contemplates that the legislature will be the one that is drawing districts.
So we have two things on the table. We have the constitutional theory and we have the empirics of how you show what is too much. Let's stick on the constitutional theory for the moment. And so Jamal, this ties directly into what you've been writing about. Weigh in. That's a question. Weigh in?
Sure. So let me say a couple of things. One, just as to this argument that Aaron's put forward, and of course it's the court's argument as well for a long time, which is that if you say that that intentional partisan advantage is unconstitutional, then every time you see a map, it's going to be at least suspect and very likely to be struck down. The slippery slope kind of goes in both directions, of course. So this came up at the Wisconsin oral argument. If you can imagine a state in its constitution, saying all of our maps must have a Republican advantage or must have a Democratic advantage, I think most of us would say that there's some kind of first principle that's being violated here. Part of the plaintiff's argument is that there's no difference between that and what's happening here. And so the question is, what is the first principle that's being violated? Is it something to do with any kind of intentional partisan advantage? Is it something to do with the degree of partisan advantage? Is it something to do with the kind of partisan advantage, right? So, or the kind of intent we're talking about. So we can think about a couple of different ways of thinking about intentional line drawing that takes into account the political party being affected. On the one hand, you might think of kind of intent as a kind of volition, right? So in a bipartisan gerrymander, the legislature is taking into account who's being affected in any particular district. It's intentional, but the motive there is some kind of competition between the parties. On the other hand, a typical partisan gerrymander is a different kind of motive. It's what you might call a kind of invidious intent. The idea is to make sure that the other guy gets as few seats as possible. Question is, can courts distinguish between those two things? I think they can. I think they have in other contexts. So if you think about racial gerrymandering, for example, here's the analogy in Rick's case. The Shaw versus Reno kind of racial gerrymander, where you're taking race into consideration because you're trying to figure out the right balance between the districts, is very different from a Gamillion versus Lightfoot kind of racial gerrymander, where the idea is to make sure that black voters don't get representation, right? So how do you figure that out as a matter of process? Well, the same way we usually do with litigation, right? You use your judgment, right? So you think about the evolution of the map. You think about the instructions given to the map maker. You put people to sworn testimony and make them say what their motives were under oath, right? You're going to get some of those things wrong. You're not going to be able to weed out every partisan gerrymander. Judges aren't perfect. Courts aren't perfect. Courts under-enforce constitutional rights all the time. But you're trying to enforce a certain norm, a certain kind of first principle that, we don't pass legislation that is intended to benefit one party over another party, right? If the Democrats passed, Medicare for Democrats, right, we wouldn't pause and say, well, before we strike that down, let's figure out what the health outcomes are for Democrats versus Republicans. You'd say, well, there's something about first principles here that's being violated. So I think that's the direction one would go in if you wanted to focus on intent. And of course, there are problems of proof and judgment and so forth, but that's standard constitutional law stuff.
Well, I was going to ask Pat if we could bring him into the discussion. So one of his areas of expertise is public opinion about politics. And I wonder if you can shed some light on how people perceive the democratic system, what things affect their perceptions of the fairness, the legitimacy of the system. I don't know if you've done anything specifically about gerrymandering, but the range of issues that people are now discussing concerning the structure of democratic processes and what public opinion survey tells us.
Yeah, sure. So I think the first thing to keep in mind is that we are in an era of unprecedentedly low levels of confidence in all kinds of institutions. That includes every democratic institution here in the United States. So you start there, which is you've got an American public that is deeply distrustful of what the system produces, deeply distrustful of those who run it and run for office. So levels of confidence in Congress, for example, just as an institution, are very low, and that's true whether you ask that of Republican voters or Democratic voters. It doesn't matter who's controlling the institution. And that example can be iterated across lots of different institutions in American politics and government right now. So I think this debate unfolds amidst that broader context that is really flavoring everything. I think gerrymandering is something that most voters don't really think that much about, frankly. It's a kind of a confusing notion, and certainly it's one, given that most people don't even know who their member of Congress necessarily is. They're certainly not keeping track of how lines are being drawn or redrawn at any given time. But one thing that is definitely the case is that voters, even in our polarized era, seem to be willing to embrace remedies that move us in the direction of what they perceive to be fair. And that's true even if those remedies seem to have a benefit for one party or another, even if that's not the individual voter's preferred party. For example, a phrase that says, let's take the drawing of district lines out of the hands of politicians is one that can get you about 80% of the public saying, yeah, let's do that. There's something very sort of straightforward, right, and obvious about that to even somebody who knows a fair amount about politics. That's not most of Americans. Most Americans, again, are already distrustful of politicians, so they like any kind of solution that seems to take away power and power from politicians over these kinds of things. And so that, that then plays into a number of things, and I know we're going to talk about this as well, but, we see states, whether they're very blue or very red, adopting these nonpartisan districting commissions by referendum, by the direct democracy. And that, again, that happened in California, even though that was clearly to the detriment of the Democratic Party, which typically controls the whole process. It just happened in Missouri on last Tuesday, where Republicans control the whole process. And in each case, what you have is a majority, and in many cases, a very big majority of voters who intrinsically find that idea appealing. And so that is, I think, part of the revolt of ordinary voters against this polarized system, which they find to be perhaps not unfair because of gerrymandering per se, but illegitimate and one that deserves a lot of skepticism.
Pat, do you have we done any public opinion polling after the Missouri election? Because it's quite fascinating that you have a pretty strong Republican tide in Missouri this past election in 2018. And at the same time, you have the vote in favor of taking redistricting out of partisan hands. And in general, I don't want to overstate this, but in general, Republican voters tend to be more distrustful of institutionalized commissions or any kind of structural reforms of the political process. So do we have any indication of how to explain this mixed result in Missouri?
Yeah, again, I think California, which adopted a nonpartisan district commission in the last decade, I think, and Missouri are kind of nice examples because, again, big blue state and now big red state, both doing the same thing. And in both states, exit polls found kind of mirror patterns of voting, which is that members of the party that was more likely to lose in this process, that is, lose power over districting, were less supportive of these commissions than the party that standed to gain. So in California, Republican voters liked the commission more than Democratic voters, but everybody liked it to a certain extent. And Missouri, it was just the opposite, which is Democratic voters liked it more than Republican voters. And I haven't seen the exact numbers, but it may be even that a plurality of Republicans voted for this thing in Missouri.
Paul, did you?
I was just going to say, it may be that most people don't know who their congressmen are and don't really care about this stuff, but the reality is, as Pat was ultimately saying, there does seem to be an upsurge of popular interest in this that's quite remarkable, sort of like the term limits movement of years back, with these organizations all over the country pushing for these independent commissions. And I think if the court doesn't actually help us fix this problem, that will be all the more of a thing, because people associate this problem as one of the really big parts of why the government isn't working anymore. And
Although, of course, the option to create these commissions is much more available in the
Sure.
states that have the direct democracy voter initiative process. And it's only been, I think, one legislature that has kind of voluntarily, but in the shadow of a potential voter initiative in Ohio, made this switch. So, but it is true. I mean, you know, one of the things that's remarkable to those of us who've been working on these issues for a number of years is, as Pat said, you know, we've been talking about the need to get this out of the hands of political actors, put it in the hands of commissions, and for years, voters didn't really respond to that to a significant extent. And suddenly, in this decade, and maybe partly the visibility of the partisan gerrymandering litigation plays a role, maybe partly the fact that people perceive how Congress is so finely balanced between the two parties and so much is perceived to be at stake now in how the process of districting takes place, so that even in Maryland, they're going to try to squeeze out one more Democratic seat in an overwhelmingly Democratic congressional delegation, not because they care about the delegation, because that may make a difference in Congress overall. But something has happened. So that in this past election, voters in not just Missouri, but Colorado, Michigan, possibly in Utah, it's a very finely balanced vote now, 50-50. In the wake of California and Florida, also imposing by voter initiative changes on the process, we're really seeing an upswell of popular visibility and mobilization around this issue. That's remarkable.
There's one more issue that plays in, that in the past decade, when there have been referenda on redistricting commissions, the party that thought it was in the advantage position in that state sabotaged or tried to sabotage the vote in favor of commissions. I'm thinking of Ohio, for example. And with the parties being so much weaker now, there seems to be less institutional opposition.
Well, I think the parties are afraid of the voters on this.
Yeah,
I think it's more that the public pressure on this has reached a level where the parties don't want to be seen as too obviously resisting that. They may try to resist it through the back door.
So
but
let's bring Adam in. And Adam, you're kind of the wild card in this debate, because you've been pushing this idea that you know, at the same time that the Supreme Court has been scaling ever more granular in terms of you have to show individually in your particular district that you didn't get to vote for whom you wanted, you have taken the position that you have to expand the lens, the aperture, not contract it, and look at the national impact to see whether there's really any distortion in politics. So
Right.
weigh in.
So I was just about to jump in because I think that this discussion actually highlights the importance of that fact. Now, I want to distinguish between what we think the kind of central harm is that's caused by partisan gerrymandering from the way we might think about remedying it. But I think this conversation has shown essentially that the core harm that people tend to focus on when they think about partisan gerrymandering is the way in which it biases the composition of the legislature. You know, that's where Steve started with his discussion about measures of bias. You know, Rick, when you were showing that slide, like what that slide was showing was the overall potential to skew the structure of the legislative assembly. And on election night, when everyone's, you know, sitting around their TVs watching the numbers come in, you know, for the most part, people aren't, the media coverage is not focused on, you know, the Maryland delegation and whether it's biased. It's focused on whether Maryland can, you know, squeeze out one more seat because that might tip Congress. So, you know, I do think that the court's, you know, conceptually made a mistake in thinking that we can identify these injuries at a retail level, at a district level, because the core injury is to how parties, candidates who represent parties, can translate, you know, votes in favor of that party to seats in the Legislative Assembly or in the Congress. And that means really the injury is one that's a nationwide injury. Now, courts aren't going to hear those kinds of cases, right? And of course, it's possible to design litigation strategies and constitutional tests that allow courts to police gerrymandering without having to tackle the nationwide problem. You know, in Gill, when the court said, you need to show injury at the district level, I mean, that could mean, like, as people have said, that could mean a number of things. And if it just means you need to show me a plaintiff in that district, along with the evidence you've got about, you know, bias in the plan, then that's going to be a showing that plaintiffs can easily make. If it means that plaintiffs need to show the intent of the legislature with respect to that particular district, that's also probably something that can be kind of shown at a district level. But if it's demonstrating the way in which the legislature's districting choices diluted the votes of some constituents, then I think identifying that injury without making any reference to what's happened in other districts
Other states.
or other states, right, is basically a conceptual impossibility.
But you've divorced the various components of a known constitutional harm, because we usually think there's an act, there's an intent that is excessive in one direction, and there's impact. And now your definition of impact is removed from the actors who have drawn the lines in Wisconsin, because it depends on what also happened in Colorado and Utah. So you have, in constitutional theory terms, you have this gulf that seems unbridgeable by current doctrine.
I mean, I think there's lots of prophylactic constitutional rules that kind of operate in this way, where we have complex systems, where there's coordination among a bunch of different actors, and we observe an effect that seems constitutionally harmful. And sometimes courts can wrap their heads around prophylactic responses that address particular actors, give them instructions, and solve the problem. Other times, like in the claims about racial disparities in the death penalty context, courts couldn't do that, weren't able to do that. That was a failure. But I think, you know, when we think about the commissions that are now being adopted by a number of states versus judicial involvement, the commissions point to this coordination dilemma. More and more states are adopting them. But if there's a set of states that are kind of holdouts at the end of the day, and if those states all happen to be states that are consistently controlled by one party, then I think folks will still be concerned about partisan gerrymandering because the results in those states will still have ultimate effects on the structure of Congress.
Jamal?
I think it's probably worth mentioning at this point, one, the kind of the wet blanket, at least for those of us who are opposed or in favor of some intervention on partisan gerrymandering, that the court is very, very likely, I think the sensible prediction would be that judges, at least as to the federal constitution, judges are very unlikely, or rather unlikely, I'll say, rather unlikely to be involved in this issue for very long. And so one of the questions that one has to look to is not just state-by-state independent commissions, but as many of you know, and everyone certainly on the panel knows, in one of the prongs of the voting rights bill that the House wants to introduce would be congressional action as to congressional districts requiring the use of independent commissions using Congress's power under Article 1, Section 4, the Elections Clause of the Constitution. Now, of course, that's not very likely to pass in this Congress, but the fact that that's on the legislative agenda both will raise the visibility of the issue, and I think really for the first time in history, I think it's plausible to say that if you were to have, in some fantasy world, 60 votes, 60 Democratic votes in the Senate, a Democratic House, and a Democratic president, that one of the things on the legislative agenda very well might be a requirement of independent commissions in every state, for at least as to congressional districts. It's a little bit more complicated to do it as to state districts, although potentially you could use the 14th Amendment to do that. So that's just worth mentioning in terms of this holdout problem. The legislative solution, which at some point seemed like a pie in the sky sort of thing, looks like it might potentially be more probable than the judicial solution.
Can I come back to ask Steve a question? We've had so much discussion about partisan gerrymandering and issues about litigation in the courts, but to step back a little bit more broadly, of the, let's say, disadvantage Democrats have in House elections, if that's the right way to put it. So the Democrats had to have about a 7-point national victory across all House seats in order to get to the number of seats they now have, whatever it turns out to be finally in the 230s. How much of the hurdles Democrats have to overcome in House elections and state legislative elections is attributable actually to partisan gerrymandering, which some of us believe has occurred very strongly in at least a certain number of states, and how much is it due to what we know to be true, which is Democrats today, much more so than 25 years ago, are so hyper-concentrated in the cities and so much less dense in their presence outside the major cities that when you draw traditional districts that are reasonably compact and follow county boundaries in towns and cities, you're inevitably going to have a situation in which Democrats are going to be disadvantaged just by the geographic differences in how Republicans and Democrats are living these days. Sort of what percent is, which of these factors, if it's possible to say?
Well, I'll be a wet blanket on both factors. So the Democrats won about 51.5 to 47% and change, and they're up a few percent in the seats. We don't know what the total number is going to be. So if there's a bias against them in the aggregate, maybe it's 1% in seats. So it's like 4 seats, 5 seats, 6 seats, somewhere in there. Not quite sure where. Some of the problems were fixed. Some of the bigger problems were fixed in Florida and Pennsylvania. Democrats have some favorable maps. Republicans have some favorable maps remaining. So it's like, 4 to 8 seats, say, that the Democrats have a little bit of have a penalty in the map nationwide right now. So that's where the bias sits right now. And judgment is whether that's a big thing, or do I care about that? Is that a small thing in the scheme of things? How much is it worth in terms of fundraising? However you want to quantify it. So that's on the one side. The other problem is there's an argument that comes out of European politics called Tobler's Law that my colleague at Stanford, John Roden's been pushing pretty hard, which is that Democrats are concentrated in the cities. He and his colleague Joey Chen have done a lot of simulations of different maps, and it looks like, well, maybe that accounts for half a seat in Florida, right? Not 7 seats in Florida. So that's the magnitude of that effect, even for its advocates. But the argument that the Democrats are super concentrated in the cities is half an argument, because that means the Republicans are super concentrated somewhere else. Turns out the Republican concentration is just as high in the rural areas, and what's really at play are the suburbs. Right? That's where you get a mix of a lot of independents, Democrats, and Republicans. So it's a matter of how you configure the lines. Do you have districts that are all rural against districts that are a mix of suburbs and cities, or do you have districts that are all city and a mix of rural and suburb? So it's really a matter of where you put those boundaries, how you tilt things. I think the biases, personally, looking closely at a lot of maps, are less severe in the congressional maps than they are in the state legislative maps, and a lot of the problems really are at that level to a much more severe degree, and that hasn't been fully digested yet.
But let's
terms of
take
this current cycle.
let's take the Gill, what we have as doctrine coming out of Gill, and so we have a push toward First Amendment, and yet at the same time this very fine-grained analysis of what the harm is. Can you, Steve, could you operationalize that? Is that something that you could envision a methodological approach to how to test for an effect empirically with the parameters that the court has given us?
At a district level, or at a, so they want to, there's an attempt in Gill to be consistent with Alabama Legislative Black Caucus, which says we want a district level approach to racial gerrymandering. So they're trying to keep these two things, racial and party gerrymandering, on the same scale. That's where I think they're coming from. And there are a lot of tools for doing different kinds of analyses. They're not the usual tools that we use to assess a map. We usually think as political scientists about an entire map. Is this map biased one way or the other, rather than is this district biased? That concept doesn't really make much sense.
That's what I was getting at.
Yeah.
It's very hard to envision how one tests for this
So
proposition.
the tools have more to do with what was done on the boundaries of the district when it was constructed. What precincts were moved in, what precincts were moved out, what were the compositions of those precincts, what are the, what can we say about other factors that might explain that? In fact, that kind of evidence was extremely important in the trial court in Florida, more so than the assessment of any kind of map. And in the racial gerrymandering case in North Carolina, that kind of evidence was very important. So there is a precedent for using that kind of evidence as opposed to some sort of singular bias number.
This is a simulation of the boundary decisions of moving precincts in and out, the effect and the...
It wasn't even a simulation. It's like, what did the Florida State Legislature do between version A and version B of the map? Which precincts were moved, and what was the consequence of that for whether the district was a Democratic district or a Republican district? Who drew the map? Who was in the meeting, and so forth. Paul?
Yeah.
Well, I was just going to say, I mean, there was at least a hint in the Common Cause brief in the Supreme Court at the beginning of the North Carolina case that they have a slightly different approach to how you decide which districts are sort of overly partisan in the way that they're drawn, and at least, and maybe Rick can explain this more, I don't know. The idea seems to be that you're going to get these randomly drawn maps, as Steve referred to, and they can do 10 or 15 or 1,000 million of them now on computers in a few minutes. And the comparison then would be, if you have a very red or blue district in a particular part of the state, well, you could do a statistical analysis of what is the likelihood in a nonpartisan process that you would end up with this district, anything like this district. And the argument seems to be that if it's very, very unlikely, that is the best evidence of excessive partisan skew in the drawing of that specific district without reference to the rest of the map. I mean, that seems to be the way that the Common Clause plaintiffs are trying to avoid the overall map dilution inquiry, which is the one we're still ultimately saying has to be part of the analysis. I don't know if you've got that right?
Well, without giving Aaron too much of our strategic approach to the case.
It's in black and white in the public domain, Rick. I mean.
Well, only the initial part of it. But as Aaron said earlier, the Supreme Court, when it first opened up the idea that partisan gerrymandering does violate the Constitution, which was in the mid-1970s, as part of the Voting Rights kind of revolution in American constitutional doctrine, also in legislation with the Voting Rights Act in 1965, the Supreme Court recognized very early on, yes, partisan gerrymandering can also be a constitutional injury, but they were torn about how to think about the way the courts might address this issue. So as Aaron said, they were reluctant to say, well, the mere intent to try to gain partisan advantage by moving people around based on records of the voting history of precincts, we're not sure that alone should be sufficient, because the concern is maybe that happens all over the place, and we don't want the courts involved in second-guessing or overseeing every districting process. So what they said is, in addition to that, you have to show not just that there was some direct effect, but what they called consistent, ongoing degradation of the political process, which led them down this path that they've been trying to follow ever since of, well, sort of how much harm to the process or how much partisan gerrymandering is too much. And the court has said, most of the justices have said, extreme partisan gerrymandering is unconstitutional. But
All of them have said that.
all of them except for Justice Kavanaugh, who hasn't weighed in on these
Wasn't there
issues
yet,
at all.
right,
Right. But because they've been worried about this path, which says we have to decide how much is too much and when it goes too far, they've been tied up in knots about whether there's a judicial role that they're comfortable with courts playing. So in a sense, what this case does, the North Carolina case, which is, I'll say even before I got involved in it, I always thought was the strongest case to take to the court, because in this process, the North Carolina legislature, in its redistricting criteria, in its formal written criteria, said, we want to create 10 Republican districts and 3 Democratic districts. And the leaders of the legislative process, because they thought there was no constitutional constraint on doing whatever you wanted in the name of partisan gerrymandering, very openly, brazenly said, this is a political gerrymander. One of them was asked, why didn't you create 11 Republican districts? And he said, well, we just couldn't figure out how to do it. And one of them said something like, well, we think it's better to have Republicans in government than Democrats. So the North Carolina case presents, in my view, the most pure, brazen, direct case of obvious partisan intent to take a state which is, more or less purple, relatively evenly divided in statewide votes, and intentionally create a 10-3 Republican delegation. And by the way, in this last election, even though Democrats did increase their vote share in the state by a little under 3%, they still remain with a 10-3 Republican delegation. So in a sense now, the court, one of the plaintiffs, my group of plaintiffs, is presenting a case which is challenging the court to think harder about this intent prong, and maybe you really ought to recognize that at least where the partisan intent is as blatant and direct as this, that this has to be a violation of the 14th Amendment or the First Amendment or both.
I mean, I think both teams are going to argue that this case could be decided very narrowly on the ground that if you announce an official policy adopted by majority vote of the committee to maximize partisan advantage, that by itself makes the process completely illegitimate, regardless of all these subtleties about which way where you draw lines and prove intent and all that sort of thing. Whether the court will be interested in that depends on what 5 justices think, but we'll have to see.
So just a couple of thoughts in response. I mean, the first is that I will just put these comments in context, because I do think that it's worth knowing what led the North Carolina legislature to be saying what they said, which is roughly 15 years ago, North Carolina Republicans challenged a democratically drawn North Carolina map, saying it was an unconstitutional racial gerrymander, and 5 justice majority on the court said, no, it's not. It's a partisan gerrymander, and that's perfectly fine, so this map is okay. So, they're not like crazy idiots. The Supreme Court wrote an opinion telling them partisan gerrymandering is okay, and indeed is your defense to racial gerrymandering claims. So after they had a map struck down as a racial gerrymander and tried to defend that map by saying, no, this wasn't drawn racially. This was drawn on the basis of politics, just like you told us 15 years ago we could do. The court said, no, we really think it was drawn on race. So the next time they said, okay, you thought we weren't clear enough, so if that was the problem, we'll fix it for you. You got it.
That problem's taken care of.
It's really hard to look at these cases in isolation without understanding the entire context of the back and forth between racial cases and partisan cases and how they interact and how, and I think is part of the frustration in this stand, because I think a lot of people, one of the frustrations is that people quite frankly don't like seeing racial gerrymandering cases really being all about politics and just dressed up as race, because that's an easier box to go into right now. So I do think there is kind of that dynamic going on. But the other piece of this is, while I understand the attractiveness of being able to say, oh, well, at least we can just have a rule that says you can't say you were doing it. I don't really see how that's a rule that furthers any of these democratic goals that everybody's talking about. I mean, we really want to say, as long as you're super covert about it so that you're not actually accountable to the American people and the voters in what you're doing, we'll give you a pass. But if you tell people, this is how we're drawing our maps, and if you don't like it, go and have independent commissions instead, whatever the solution may be. I'm not sure why any of us would think that the good solution to all of this is simply to say, just don't admit it.
So a couple of thoughts on this. First of all, the Democratic gerrymander of the 1990s in North Carolina was in response to the Republican Justice Department using the race issue to force redistricting of the whole state. So we can go back to find original sin, way back if we wanted to. But
It feels like the Middle East now.
North Carolina right now is sort of like the Middle. But anyway, But the point you raise is really a significant one, because it goes back to a lot of the academic discomfort with the Shaw line of cases. There was a sense from Justice O'Connor that, in her famous line, appearances do matter, and that there is some democratic polity insult to doing things too overtly. There was in the context of race. And so this line that she drew, that all of us as academics were, this is not a line, this is not possible, but it proved to be sort of okay and workable. And the line was, you can of course take race into account if you need to for some reason, just don't make it the driving factor. Don't organize everything around it. It wasn't intellectually satisfying, but it sort of did the work. And all of us, I mean, Rick and I moved there, I think, a little bit earlier certainly than our co-author Pam Carlin did, but all of us moved in the direction of accepting maybe there's something to it, even if we can't put a complete intellectual rationale to it. And so if you go from North Carolina to Maryland, where you don't have a legislative process organized this way, you just have the intervention of a Democratic governor to do the exact same thing. That's why I sort of think the Maryland case is easier for the court to grapple with, because it's one district, and so it doesn't have the standing and all those kinds of issues. But the overtness and the unidirectional intervention into the legislative process by the governor, that does seem to feel wrong, even if we don't have a complete theory, doesn't it?
Look, I mean, I think, I'm not here to defend, and I don't think most people that are involved in the litigation here are all about defending why it's a great thing to have extreme partisan gerrymandering as the way that people draw districts. I mean, that's not the question in litigation. It's not the question before the court. The question in litigation is having the courts step in and try and figure out which ones are the extreme ones and which ones aren't, and having the courts step in and draw the maps themselves instead of legislatures doing it. Is that really a solution, or is that a cure that's worse than the disease here? And that's really, the dynamic of what they're struggling with in Gill and what they'll be struggling with next time around is, and I think, Ben, a big part of what we're talking about today, I mean, part of the reason, the difficulty is it does feel like where the concern and the problem is at a broader level and is at kind of a statewide level or a national level, and that's what's animating this. That's what's really why people are doing it. They're not usually doing it because there's one particular district they care a lot about. But that's exactly what makes it very difficult to think of it as something that the courts are there to fix, because courts are there to adjudicate individualized disputes, not to kind of solve all of the nation's political woes.
So we have a spread here. We have Jamal, who thinks, I think based upon the Shaw experience, that this is the kind of fact-finding, line drawing that is difficult in general, but that courts, common law origin courts, are actually have done for centuries, and it doesn't seem that taxing. Adam thinks it's misdirected inquiry, because if the insult is to the polity, courts actually don't have the tools available to them. Steve thinks it's not worth doing because the impact is just not that great across the board. So we have fair consensus, I think, at this point.
Sam, can I add one more thing to that mix, which I think...
And nobody cares,
Yeah,
right?
yeah, exactly. And no one cares, or no one knows, and everyone's angry about it. So I want to kind of throw in an observation, and I want to hear what Steve thinks about this observation, which is there are two kind of common sense criteria that I think everyone in this room would find appealing about how districts should be drawn. So the first is that they should be compact. In fact, they should look as much like a circle as possible, given the constraints on them all being of equal population. And the second is that as much as possible, they should observe political district boundaries, like county boundaries or municipal boundaries. And it's my sense that both of those criteria, which are often written into things like how a state redistricting commission should be drawing lines, disadvantage Democrats compared to the Republicans, as long as Democrats are squeezed into these urban areas. And just as an illustration, think about Manhattan. If I am trying to not cross the Manhattan boundary when I'm drawing districts, and I'm trying to draw as compact districts as possible, well, that creates lots of compact districts below the Harlem River that completely waste, most Democratic votes. And so just to throw another wrench into the works, which is that these common sense criteria for what make good districts that we would expect to be included in a lot of these impositions, whether they're court-based or voter-based, on how districts should be drawn, are still going to be not very good for the Democratic Party. Now, Steve may have a different sense, but that's my observation.
So my sense is there are actually a lot of criteria that we desire. We want racial fairness, we want partisan fairness, we don't want the incumbents to put their fingers too heavily on it, benefit them personally, and so forth. So you can come up with a lot of criteria. And, a state like Florida has a lot of criteria now in its constitution. And the point of a thorough hearing and trial is that those who are unhappy with the map can come forward and say, we can do better than this, or we can't do better than this. And that's, in fact, exactly what happened in Florida, which is plaintiffs came forward and said, here are the 8 criteria mapped out in the state constitution. Here's a map that is better on all 8 than the map that the state legislature passed, crosses fewer boundaries, less partisan bias, on down the list. So there's no, in terms of the maps that are actually being produced as opposed to a theoretical matter, there's no, I don't think there's much of a trade-off here between those traditional criteria of minimizing the number of times you cross a county line or a municipal line, and creating a reasonably fair map and respecting minority interests and so forth. It's just that the legislatures, if they feel they're not being watched, and this is the important point about the court, if they feel they're not being watched, on either side of the aisle will misbehave, and in ways that may not be horribly consequential, but are ways that are kind of eroding.
And that makes me want to respond to Aaron's comment just briefly. And my view has been that precisely because the courts have not dropped the hammer and said in any context, at least at the Supreme Court level, that something is an unconstitutional partisan gerrymander, even though formally it can be unconstitutional, but they've never found one that is. The lower courts now are reaching that conclusion. If the Supreme Court were to strike something down as an unconstitutional partisan gerrymander, even if it's, in an extreme context, and the intent might be less obvious and overt the next time around, politicians, in my experience, are so careful about preserving their seats and are so risk-averse about losing control of the process that if they know there is some constraint there on partisan gerrymandering, I think that the amount that they will kind of back away from that, I'm not saying it's going to go away, but you will get some significant benefit well beyond the formal scope of whatever the doctrine is, because now there's a threat. Now you're at risk. And when you ask your redistricting lawyers, how do I do this to make sure there's no chance we get drawn into court or that we're going to lose a lawsuit? If there's a constraint out there, it changes the dynamics quite a bit, I think, as opposed to a world in which they now feel free to say, and maybe that they have to say, of course this was a partisan gerrymander. And the other thing is Aaron's comment reminded me of a conversation I had with Justice Scalia at an academic conference, not in public, but early on when the court was developing these constraints on racial gerrymandering. And I said, look, you can develop these doctrines, but redistrictors are going to know that the west side of Chicago or the south side of Chicago is, overwhelmingly minority population. The city isn't, or the Detroit is overwhelmingly African American and the suburbs aren't. So how are you going to, get this out of the process? And he said, that may be true, but the doctrine shouldn't be that that's permissible. We may not be able to drive it all out, but the doctrine should say this is not something that's constitutionally acceptable. And it may be that's kind of the best answer to the kind of question that Aaron is raising. That is, in my view, that we do need some sense of a legal constraint here, and it will radiate beyond the formal bounds of the doctrine.
So, Jamal, in your foreword, you have a view of constitutional law that's much more modest than has been asserted in the classic rights domain. And it seems to me that the argument that Rick just put forward and the kind of soft empirical constraint that Steve was describing, it should be quite amenable to you, that is something that you think courts could do.
Yeah, and the forward is 105 pages, so I don't know that I can describe it very easily in 5 minutes or 2 minutes, but the basic argument is an argument against kind of reflexively thinking about rights as if the only way or the presumptive way to think about rights is in an absolute sense. So if you have a First Amendment right to not have your party affiliation count in the redistricting process, that means that right can be exercised to the maximum extent, right? That argument, which I think is fairly consistent with the way we tend to think about the First Amendment. For example, the forward is an argument against those kinds of claims, in part because I would like for us to be more creative in thinking about judges as being participants in a political process, a process that tries to lower the stakes of politics, that tries to encourage negotiation among political actors rather than a kind of scorched earth regime in which there's a rights claimant on one side, and if they win for all time, and if the government wins, they lose for all time. I think that kind of posture that we tend to adopt towards rights contributes to polarization, contributes to a kind of social distance between people. I wanted to make an additional an additional point here, and it relates a little bit to Steve's empirical case. There's a mystery here. If it's the case that gerrymandering in the grand scheme of things at the national level, certainly over time, doesn't strongly benefit one party over another, then why are we so dug in on this issue? Why is it the case that Democrats have tended fairly strongly to support limits on gerrymandering, and Republicans have not, or however you want to divide conservative, liberal, so forth? And it's not just about judges, because you look at the Arizona case, right, and look at the attack on independent commissions, where we lined up along political lines, where conservatives said, no, there's a constitutional violation in giving this power to an independent commission as opposed to the state legislature, and Democrats, of course, lined up on the other side. So one possibility is that there's something about good governance or something that, I mean, that's maybe the most naive possibility that Democrats kind of like and Republicans are more skeptical of. They don't like government in general, and so when you say good government, that is grating in some way. Another possibility is in recent history, Republicans have tended to control state legislatures more. I'm skeptical of that because this divide over this issue lasts beyond that period. In some ways, I might put that a little bit to the panel. It's the kind of question one asked. It's a kind of Chicago question, right? If we observe that this doesn't matter that much, why do we line up in this way? Doesn't the fact that we line up in this way tell us something about expected outcomes? Are we being irrational, or are we being rational?
So, Aaron and Paul, from the litigation perspective, there's this argument about the symbolic or expressive value of the court saying, even if it's hard to operationalize, this is really, at some point, just too ugly to permit in democratic politics. Does that have any traction at all in court jurisprudence now?
Well, sure, if there's a rule that can be enforced and has been enforced that says a map at some point can become extreme enough that a court is authorized to throw it out, then the legislators are going to, as Rick said, going to take that into account. We have some discipline of the process. It'll also distort the process in other ways in terms of hiding things that might otherwise have been said in the open, but eventually they're going to try to avoid having courts draw the map or have to redo the map, I would think. I mean, the question is, can we get the courts to do it?
I mean, just to respond to some of what Jamal was saying, I mean, I'd offer another explanation for why the kind of ideologically people tend to line up where they line up, and I think that's because for many conservatives, this issue is an issue that we view as about the appropriate role of the courts and the power of the courts in our system at a constitutional level, at a separation of powers level, at its own good government level of are courts where we want political disputes resolved? Are courts what we want to be, the institutions who are making essentially political judgments? And I think that's not simply about outcomes. I mean, if it were, then I think you would see the Republican Party kind of supporters and the Democratic Party supporters flipping roles entirely in the Maryland case and in the Wisconsin case or the North Carolina case, and you'd see over time more of a shift than you have among the parties. But I think, my sense is in decades of litigation, no matter which party kind of was benefiting from gerrymandering at the time, I mean, almost all challenges have principally been brought by people that are more left-leaning and defended against by people who are more right-leaning. And I think that has less to do with any kind of political outcomes and more to do with how you think about the issue of, what you think the role of the courts is and what you think the role of the courts should be in something.
Aaron, there used to be a time when legal conservatives didn't think courts should be making political decisions, but that's a long time ago. I mean, nowadays the conservatives on the court and in your world are sure we should decide how many guns there are in the country. The courts should decide that. We should, whether we have a voting rights act.
We have a Second Amendment in the Constitution,
Well,
so that
right,
may be
but-
why some of us are defending that
But
proposition.
of course, they changed the 9 justices when I clerked understood that amendment had nothing to do with the individual right, and it changed. And that's because they decided that they would change it. And
I mean-
the political decision was made by the justices.
I'd
And
be
so-
welcome to have a whole nother panel debate on the Second Amendment, being,
I mean,
being it's the only thing I litigate more than this issue, but,
It's simply not true that conservatives are more opposed to judicial resolution of difficult political issues now than liberals. It's just not true.
I mean, I am a conservative, and that is actually my motivation in what I think about
Can I say
this
something to
issue. So,
support,
you know.
a minor point to support Erin, because we also promised her we wouldn't take
Good.
advantage of the fact that there are 7 or 8 of us here.
I mean, I think I'm at
who are
least allowed to
basically-
speak for what is animating people on my side of the debate and be
So,
expected to be genuine.
You know, going back to when the Supreme Court first, in the mid-'70s, said that constitutionally partisan gerrymandering could become a violation, you know, even at that time, and in the 80s, you had justices like O'Connor, Rehnquist, I forget who the third was, arguing that no, the court should stay completely out of this matter. And that was in the era in which, if you go back to that graph I showed you at the beginning, you know, Democrats were overwhelmingly in control of legislatures. Democrats were the ones who had much more power to engage in gerrymandering. And yet this idea that the whole area is not one that courts should get involved in for a variety of reasons was strongly articulated by Justice O'Connor and others. So even in that era. So
Well, but
that's
it
a
was
litup bit
more-
of support.
It was more mixed. We want to open up
Yes.
the questions.
White and Powell were on the
In-
other side, right?
But if you look at the alignment of parties in Davis versus Bandemer, which is the case
Yeah.
that Rick is describing, you had the Indiana Democrats who were in one of the few states where the Republicans could really do them in, bring the lawsuit. They were joined as an amicus by the National Republican Party, and you had the Indiana Republicans as the respondents in the case, and they were joined by, as an amicus, by the National Democratic Party. So, you know, this is, life is complicated, but we want to take questions from the audience. If you'd come up to a microphone, please.
If I may start off by saying the curse on both the houses. The Constitution doesn't provide for political parties, and in my district, I believe, the independent vote is the plurality. The Democrats, it seems to me that, I don't know if it's a national movement, that you're getting a lot of people who are not registering either as Democrats or Republicans. How does that issue come into this debate? Because it certainly gets to a point where independents aren't being represented appropriately.
So I think going back to the discussion about urban versus rural areas, it's really about strongly Democratic areas, strongly Republican areas, and then manipulating where the independent vote goes to gain advantage. So the independents end up being kind of well, they end up being the tool in all this. Interesting question, like how much influence independents have in all this as opposed to how much Ds have or Rs have.
Isn't it
Usually-
fair to say, though, Steve, I mean, I hate to talk about political science in front of people like you, Pat, but my understanding is that while there's a much higher number of people who register as independents, most of those people are strongly predictable in their vote as either Democratic-leaning or Republican-leaning.
Yeah, they tend to lean, but even the percentage of pure independents has gone up. The percentage of people who call themselves independents and don't identify with either party has been the plurality now for a while.
Do we have a statistic on the amount of split ticket voting and how that's fared over time?
Yeah, it's at all-time lows.
Yeah.
Yeah.
So which indicates that independents are not
really
really
independents.
choosing independently, at least across the ballot. Is that right, Pat?
Yeah, I mean, at least within ballot. It may be that they flip from election to election, which wouldn't surprise me, but within any election, the share of folks who say, the statistic in my mind is, who vote one party for the Senate and the other party for president is in the single digits, generally in any election.
Steve, I'm struck by the fact that there may be a relatively speaking de minimis impact regarding gerrymandering on the congressional level, right? I think the common observation by most people is gerrymandering is a serious issue. It's distorting, obviously, the votes in the country there. And I think from your computer modeling and statistically, you're telling, you know, I'm walking away believing maybe it's not a great an impact as one would think, depending on, I guess, how close, obviously, the House is. On the state level,
what's happening on the state level? Because obviously many of those state races are important too, and lots of votes, obviously, by a particular person, by a particular individual, are just as important regarding what impacts their life, right, by being a citizen of a particular state.
So at the national level, part of what's happening is the Democrats gain some advantage here, the Republicans gain some advantage here, that kind of washes out. Whichever had more influence relative to the other party across state legislatures gains a little bit of an advantage in the congressional maps. But in the state legislative maps, if you had one party rule, it has a pretty substantial effect on which party ends up controlling the state legislature for 10 years. So that's the effect. I think that's the biggest effect here is not on the congressional representation, but on the state legislative.
Does Steve understand the effect at the state level?
Yeah.
Statistically, you showed on the congressional level. What's happening statistically on the state level?
Well, at state level, it's also declined since the 60s because legislatures have to negotiate every 10 years now. Before they weren't doing anything, like let the maps drift out of control. Now they have to negotiate, and that has some effect reducing the degree of bias. But there's still, in a state that has one party rule, on average, it's about a 10-point bias for the majority party. About a 10-point bias. So in a 50-50 map, you might expect a 60-40 split in the seats.
That's huge.
Yeah. So one party controls.
Come on up to the mic if you want to ask a question. Bert?
Hi, I'm Bert Newborn. I was gerrymandered off of this panel.
But in the aggregate, it works out fine because you're on another panel.
That's right. It's fine. In the aggregate, I get onto a different panel, and I'm going to talk more. But on the question of harm, which I think is a fascinating question that I really learned a lot, Norman Dorsey and I, over the years, tried to think through what we thought the harm was of partisan gerrymandering. And we actually drove it down to a granular level, even, I think, lower than any of you guys are talking about. We thought the real harm was not necessarily that it advantaged one party or another, because we found it very difficult to be able to make the kinds of judgments that the court is finding. We thought that the real harm of partisan gerrymandering is that it took the decision of who would win the election out of the hands of voters and gave it to the people who were drawing the maps. And so that it essentially denied both Republicans and Democrats. Take a look at Wisconsin, the state legislature. It denies both Republicans and Democrats in Wisconsin a meaningful vote on who's going to represent them. Because the way the map is drawn will determine the outcome of 98 out of 100 Wisconsin districts. And that means that even benefited Republicans didn't get to cast a vote in a contested election. And what we were trying to argue for is that you should have a First Amendment theory that says there is a First Amendment right to vote in a contested election, unless that's not possible because of the geographical. But if what you have is either one or both political parties drawing the line so that the elections don't matter, because you know what the outcome is going to be in advance, then you really struck a body blow at democracy. And that's one of the reasons why people don't vote, because they lose faith.
Now you're going from gerrymander to filibustering. But
Okay.
no, we have very little time, and we have three
Fair
others.
enough,
Bert.
fair enough.
Okay.
Shelley Zoller, a question. The size of Congress hasn't changed effectively in over 100 years. The U.S. population, for which it is supposed to be calculated on, has. Are some of these things a product of that difference and skewing? Because you are now in a position where you have such large differences in many instances of size of population supposedly represented, and you can play games.
If I may exercise prerogative, we're going to hold off on that question till the last panel, because on the last panel will be Jesse Wegman, who I think is here, who's from the New York Times editorial page that just came out on that point, and also Rob Ritchie, who's been discussing this issue for a number of years. So we're going to hold off on that question. Yes?
Are at-large districts that are allocated proportionally at all possible way out of any of this, or is there some
I'm going to hold off on that one also. That's
Okay.
the last panel. We're going to talk about ranked choice voting and several issues of just that sort. Okay. Yes, sir.
Just a question. I wonder if the panel members think that independent redistricting things are the solution to the problem, and would they be a safe harbor for a legislature or a state to do?
Okay, that's an excellent question to sum up. So why don't we take, we're out of time, but our panelists have at it in 10 seconds. Paul,
I think it is the ideal solution, and you do have a question about how to set them up, whether to tell them to ignore politics, in which case you might sometimes randomly get gerrymandered, to tell them to actually consider politics and try to come out to the fair result. But either way is better than the system we have now.
Aaron?
I'm highly skeptical. I think the reality is that drawing districts and drawing lines, there's politics involved in it, and you can say you have an apolitical commission, but time has proven it's not usually the case. So, I think it's just sort of the nature of the exercise.
Steve, in the ones we have, do we take solace from this, or has it just become filtered politics?
They tend to be much fairer in terms of the outcomes. We're the last advanced democracy not to have a commission on districts.
And Jamal, is the Constitution satisfied by taking democratic decision-making out of the hands of the demos?
Well, I think that counts as being in the hands of the demos, just at a level of remove. I would just say one problem, I'll just repeat the holdout problem, which is that if it's the case, I don't know if this is true empirically, I'd guess it is, that more Republican-leaning states are less likely to adopt commissions, then you'd have a stronger Republican bias if only the Democrat states go to commission. So it's a kind of unilateral disarmament that can bias the process.
And Adam, does that overcome the coordination problem that you're concerned about in your writing?
If you can solve if you can solve the holdout problem that Jamal identifies, then sure, you use separate units to solve the aggregate problem.
And Pat, does anybody care?
Well, nobody's thinking about it too much, but I think a congressionally imposed solution, as was mentioned at the beginning of the panel, and being proposed by congressional Democrats, would be very popular. One impossible to pass through Congress as it currently stands, but one that would that a lot of people would find quite appealing.
All right, so we'll close this panel up, 15-minute break, and then we'll move on to talking about political parties, primary elections, and other issues in democratic politics.